SJC-12716, Commonwealth v. Gabriel Aroian.
Mr. Crane, good afternoon. Soon to be good evening at our current rate. So,
Quite a long day here. Good afternoon. May it please the court, Edward Crane on behalf of Gabriel Aroian. I want to start by addressing the procedural due process issue. The judge denied the defendant's motion based on allegations made in restraining order affidavits that were never introduced or even discussed at the motion hearing. These allegations were contained in affidavits that the defendant never had a chance to respond to. The requirement to register as a sex offender is a significant obligation. Before such an obligation should be imposed, the defendant should have an opportunity to respond to all the evidence that is used against him. That is especially true here, where 2 of the 3 restraining orders were temporary orders granted after ex parte hearings. The plaintiffs did not show up to the full hearings, and thus the defendant never had an opportunity to respond to the allegations contained in the affidavits. Considering these circumstances, the judge should not have credited these allegations without giving the defendant first an opportunity to respond to the allegations contained in the affidavits. Moving to the second issue.
what's the consequence of it being 20 months after? I mean, the whole theory of the statute is that the judge, when it's fresh in his or her mind, can make a determination with regard to it. Here, you waited 20 months, I believe, after you'd gone to SORB in the effort to have them say you should not need to register, and they said, no, you're a level 1. Does the single justice have to give extraordinary relief when you wait that long?
Well, in my recollection, it's not 20 months. I believe that the decision on the motion occurred at the same time as the plea hearing, which was the end of March 2018.
Right, I'm sorry. So but then it was January of 2019 that you filed your 211-3. So I'm sorry, it was not 20 months, but it was still 8 months or 7 months.
I think in the context of appellate practice, that's not an unreasonable delay. After Mr. Aroian after his motion was denied, the case, it went to CPCS to appoint an appellate attorney. I didn't get my hands on the case until the fall, and then putting that, I mean, it's essentially, I think, the equivalent of an appellate brief, which often takes 4 or 5 months to put together. So I don't think that it's, the delay in filing the petition to the single justice was anything beyond extraordinary or well within reason.
So what's the standard of review? That whether or not the judge below abused his discretion and whether or not the single justice erred?
Well, I think the standard of review is whether the single justice abused her discretion. And, in this case, I think that the abuse of discretion comes from the fact that we have significant issues raised here regarding how to resolve these motions to relieve defendants from the sex offender obligation. And to have a denial, a cursory denial, I don't think is appropriate here. These are significant issues. This is the avenue through which all of the issues pertaining to these motions must be resolved. Since there's no right to direct appeal from the denial of a motion, the 211-3 is the avenue that must be pursued. And I think that the court has provided some guidance with, first with the Ronald R. case, in which it was established that the burden's on the defendant, and then more recently with the LL case, in which the court sort of clarified how to look at the risk of reoffense and what that risk has to be, establishing that it has to be something lower than low, and then also how to assess that risk in terms of looking at the circumstances of the offenses along with the defendant's criminal history. So I think that in this instance, this is the only way we're going to resolve these questions about how to the sort of the procedure for these motions.
But the risk of reoffense, I gather, would also include the risk of reoffending through the possession of child pornography.
Yes. Yes, and I think with,
And why should the judge below have found that there was essentially a zero risk of reoffending in light of the offense here?
I don't think that, I don't think the requirement is that I'm not saying the judge was required to rule in any certain way. I think really where the judge made mistakes here would be, first off, in this, going to look at these restraining order affidavits that, again, were never introduced, never discussed at the motion hearing. I mean, questionable as to whether they're really even part of the defendant's criminal history, considering their temporary orders. And then moving on to dismiss Dr. Brown's report simply because he didn't discuss allegations made in support of temporary restraining orders. It just doesn't, that doesn't seem like a reasoned basis for dismissing an expert's opinion in these cases. The court said in LL that the judge has to give serious reasoned consideration to expert evidence, and frankly, I think that in this case, it seems like the judge was looking for any reason really to dismiss what Dr. Brown had to say.
How about the restraining order that was an ex parte and the affidavit there? Can that be considered?
I think that could be considered. I think that it raises an interesting question because, first off, as to whether restraining orders are part of a defendant's criminal history, as that term is defined in the statute. But I think that could be considered. But we're looking at, with all three allegations, nothing alleging sexual misconduct. So I think even taking the fact that restraining order was granted into account, I mean, is that a reasoned basis for saying that Dr. Brown's report has no credibility because he didn't discuss allegations that were made regarding non-sexual misconduct? I mean, I don't see how his failure to discuss non-sexual misconduct diminishes his credibility with respect to the defendant's likelihood to reoffend sexually. Certainly, if these were instances of sexual misconduct, they'd be extremely relevant to the risk of reoffense. But all three restraining orders, all three affidavits, they did not involve any sort of sexual misconduct. And I think just with respect to the issue about the factors that are mentioned in the Code of Regulations there, I think those speak to, well, the statute talks about you have to look at a defendant's criminal history. I think there has to be a requirement and that factor 10 speaks to this. There has to be a requirement that that's a fair, nuanced look at the defendant's criminal history. What the judge did here is he says the defendant has an established history of recidivism and lists a bunch of charges that were never resulted in conviction. I really think that it's improper in these types of cases to say that a judge has the ability to, in assessing the defendant's criminal history, to look at cases that were dismissed, to just look at the defendant's Board of Probation record and just say, oh, well, he was charged with this, he was charged with that, so he has an established history of recidivism. I mean, I think any type of nuanced look or really more than cursory look at his criminal history would suggest, okay, he's been convicted more than a few times of operating under the influence and some driving violations, but that's it. the idea that he has this established, as the judge puts it, an established history of recidivism.
Were the OUIs convictions, though?
They were convictions.
And what about the situation with the judge indicating that he just didn't credit the defendant, that it was inadvertently downloaded? Can that be considered on whether or not to excuse registration?
No, I don't think that can be.
Because that was one of the factors that he talked about.
Dr. Brown did discuss that to a certain
And the
extent.
judge mentions it too, that he didn't credit the defendant's testimony, that it was inadvertently downloaded. I'm just asking whether that's a factor to be considered,
Well, I don't think that was,
as opposed to just that he was convicted of doing it.
yeah, I think that I don't think the judge, I mean, he's pled out to the case. He can't
well,
at that point say it's inadvertent and say that, I think all that discussion is sort of irrelevant to the question as to whether he's going to reoffend or not.
Okay, thank you.
Thank you.
Ms. Lazar.
Good afternoon. Ellen Lazar for the Commonwealth. The single justice correctly exercised her discretion to deny the defendant's petition, first because it was untimely. The defendant's petition here was filed 10 months after the issuance of the order that he was challenging. Although Chapter 211, Section 3 does not have explicit time limits, this court has recognized that a petition at some point may be untimely if it's not filed within a reasonable time period. Where the typical time to appeal is generally 30 or 60 days from a judgment or order, 10 months is an unreasonable amount of time, given that here the defendant had all of the necessary information that he needed to appeal at the time that the order issued. And as Your Honor noted, this statutory provision in particular, the trial judge is required within 14 days to make this determination about whether to relieve an offender from registration based upon what he or she has seen in the trial and the sentencing. So it's meant to be in the immediate aftermath of the conviction. So in this circumstance in particular, I would argue that this petition was untimely, and for that reason alone, the single justice correctly exercised her discretion to deny the petition. The single justice also correctly denied the petition because the trial judge correctly considered the restraining orders here, which were reflected on the defendant's Board of Probation record and were part of the defendant's criminal history, which Chapter 6, Section 178EF explicitly directs the judge to consider in deciding whether to waive the registration requirement. At the very least, the trial judge was warranted in finding that the defendant's expert was less credible due to his apparent unawareness even of the existence of the restraining order, even putting aside the content of the affidavits. There was no mention whatsoever in the expert's report that these restraining orders even existed, which indicated to the judge that the expert had not been given a full and credible history by the defendant. And even putting aside the restraining orders, the trial judge properly chose to reject the expert's opinion because it rested heavily upon the defendant's claim that he had inadvertently come into contact with all of these images of child pornography. And the judge explicitly rejected the defendant's claim of inadvertence. So given that the doctor in his report 4 times relies upon the fact that the defendant inadvertently obtained this child pornography, the judge was well within his discretion to reject the doctor's opinion on that basis alone, separate and apart from the restraining order issues. And
Thank you.
thank you.